Welcome, and thank you for joining our webinar today. We appreciate you taking the time to join us and learn about how to serve as an estate executor. My name is Kara Musa, and I'm the Senior Marketing Coordinator for the Kopenbarger & Kopenbarger law firm. We have been in business for over 40 years. We have 8 full-time attorneys, a CPA, and 1 counsel attorney, along with dozens of highly qualified support staff that are happy to serve you at any time. We have multiple locations all throughout the state of California and have the ability to conduct meetings in person or through virtual means such as this. Your presenter today is Dale Anderson, and he is one of the 9 attorneys within our firm. Dale works in the estate administration department with focus on probate and estate litigation. He works mainly in our Orange County area and San Diego area, but with new Zoom technology, he can meet with anyone anywhere. Dale is a wonderful attorney who knows the ins and outs of estate planning and is dedicated to serving every client to the best of his capabilities, both in office or in the court. Here he is, Dale Anderson, everybody.
All right, well, thank you, Kara, for that kind introduction, and welcome everybody to the new world. I'm used to giving presentations with a crowd in front of me where we can interact, but we're all doing the best we can in these different times. All right, thank you for joining this webinar on how to serve as estate executor. I guess the first thing we have to address is what exactly is an executor. Many of you have heard different terms like executor or executrix or administrator or trustee, and what's the difference between each of these terms? Well, an estate executor is basically someone who is named in a will to administer a person's estate. And in California, there are 2 basic requirements for serving as an executor. 1, you have to be over 18 years of age, and 2, you have to be of sound mind in the ability to serve. Now, a will basically nominates the executor. Just because you name someone in your will doesn't mean they automatically serve as the executor, because 1, the person has to accept that responsibility, and 2, the court has to approve them. And we'll get to some of those a little bit later in the presentation. All right, so as we talk about an estate executor, these are the things that we're going to be looking at today. First off, what is an estate? If we're talking about an estate executor, we have to cross the bridge on what is an estate. Next is, what is an estate administration? What do we mean by that term? Next, we look at what are the legal requirements or major duties of an executor. Then we'll take a look at probate, and then we'll determine how we at Kopenbarger & Kopenbarger can help you. Now, as we talk about the importance of an estate executor and how to serve, this topic is important not only for those who are actually going through the estate administration process, but those of you who are actually contemplating the preparation of your estate plan, such as who's the right person to name as an estate executor. As we go through today and look at the different requirements of what is needed to be an executor, it may help you address who's the right person to be named as the executor. So first off, the question is, what is an estate? I like to say an estate is everything you've accumulated over the years. I've been able and blessed to travel, and I've gone to the Philippines, and I like to tell people this story. What is it, the one thing that I noticed was absent from the Philippines in my travel? And it was simply this: self-storage units. We in America are so blessed. We have our 2-3 car garages and we fill it up with our stuff. And then that's not enough, so we have self-storage units. But an estate is basically all of those toys, everything you've accumulated over the years. And so an estate administration is, how do we get your toys, your property, from you to the next person? Estate administration is that. It's the process, both judicial or non-judicial, of handling your assets, your toys, and in getting them from you to the person you want them to go to. The executor or the executrix, and the difference is the executor has traditionally been a male, executrix, referred to as a female, is the person that you name or nominate in your will to handle your estate. And the administrator is someone if you died without a will, if you died without naming someone, and the court has to name that person is called an administrator. But their duties are the same, whether you're named in the will as an executor / executrix, or you're appointed by the court as an administrator, it's the same thing. Your duties will be the same. So we like to break it down in a couple of different areas. What are the legal requirements? First of all, it would be update land records. If there's any real estate or property in your name, those land records would have to be updated. For example, if I owned a property in my name, Dale Anderson just owned the property, and I wanted to go to someone else when I die, how do I get that out of Dale Anderson's name into someone else's name? So the duty of the executor or administrator is to update those land records to get them from my name into the appropriate name. Next, when you do that, you have to notify the county assessor. And why do we do that? Most of you who live here in California are familiar with Proposition 13, which prohibits the local assessor from reassessing your property except under certain circumstances. And one of those is when there's a change of ownership and or beneficial ownership. So when you go from one name to the next, that's a change of ownership. So you have to notify the county assessor, is this a taxable event? Is this an event where the county assessor can go out and reassess the property? Sometimes that answer is yes, but sometimes that answer is no. Next, notice has to go to the various beneficiaries. And I'll go over some of these a little bit later in the process. Also, you have to notify the California Department of Health Care Services of the person's death. Now, who is that and why do we notify them? Most of you are familiar with Medicare. Medicare is an age-based program. When you turn 65, you're entitled to Medicare because it's based totally on your age. Now, obviously, Medicare does not pay for everything. It doesn't necessarily pay for all your doctor visits and treatments. It's more of a safety net. But it's when you turn 65, regardless of your income, regardless of the assets you have, you're entitled to Medicare. Medicaid, however, is a needs-based program. If you don't have the assets, if you can't afford to go to the doctor or you can't afford that treatment you need, Medicare or Medicaid steps in to pay those expenses. Medicaid is a federal program that's administered by the various states. And in California, it is administered by the Department of Health Care Services and is known in California as Medi-Cal. So when a person dies, notice goes to the Department of Health Care Services and they search their record to say, have we made any payments on behalf of this deceased individual? Because if they have, then they file a lien against that person's estate. We had one estate we were administering some time ago where a lady died and all she had was a will. She didn't have any trust or probate. So notice went out to the Department of Health Care Services and they wrote back, we have a $13,000 lien against that person's estate. We went through the whole probate process. She had a home that was her major asset. We had to sell the home to have the assets to distribute. The first check that went out was to the Department of Health Care Services for that $13,000 lien. So one of the responsibilities of the executor is to notify the Department of Health Care Services of this person's death. Another requirement under the California Probate Code is to lodge the last will and testament in the county where probate would take place. We call it lodging it for safekeeping. And the probate code says that within 30 days of a person's death, the custodian, that means the person who has physical custody of it, of the original will, is to file it in the county where probate would take place. Now, when I say the original will, we're not talking about a copy of the original. We're talking about the actual will that was actually signed, frequently referred to in the industry as the wet copy, which means it's the one that had the wet ink copy on it. So within 30 days of a person's death, that original will is to be filed in the county where probate would take place. And that's normally the county where the person was living or had their major assets at the time of their death. Now, we also quickly say that there's no will police sitting at the courthouse on day 31 saying, all right, where's that will? But it's one of those issues that the probate code requires. The history of it is they wanted the will there to protect it from being damaged or changed. One of the ways of revoking a will was to simply rip it up. One way of amending the will was simply line out people and initial it or sign and date it. And so there were problems in the probate process, and then as things went along, families would start fighting, and then one sibling would say, I've had it with you, and so I'm going to line you out and cross you out and sign mom's name to it. So before all those issues arise, the probate code says get that will into the court as fast as possible. Next thing is that when a person dies, many of you know, their social security number or their tax number dies with them. So when somebody dies, the day of their death, their social security number dies with them. So a new tax number will have to be given in most cases to account for any income that is made from that person's assets until the time of final distribution. So one of the duties of an executor is to obtain a new tax number for the person who passed away. Next, the person would have to, the executor would notify both the federal and the state taxing authorities that they are now the person responsible for the final tax returns of that deceased individual. Whereas mom or dad or whomever the decedent is sign their own tax returns, now that they're dead, obviously they can't sign their own. Well, let's say somebody died in June of this year. Well, that's 6 months of 2020 for which a tax return would need to be filed. And it would be the executor's responsibility for filing that final 2020 tax return by April 15th of next year. So you have to notify the state and the federal taxing authorities that you are now the person that's going to be responsible and signing those estate or those tax returns for them. So, and when somebody dies, there are various tax issues. As I just said, there's a personal income tax returns that would need to be filed. Also, if during the administration process, the estate is making money, either through interest or dividends or some other taxable gains, somebody's going to have to pay those taxes. And frequently that's done by what's known as a fiduciary income tax return. Whereas we as individuals file a 1040, a fiduciary tax return is a 1041, and that's filed on behalf of the estate. Right? The administrator or executor would also be responsible for filing any required estate tax returns. Now, currently, if a person dies and their estate is under 11.5 million, there is no state tax return that even needs to be filed because there's no estate tax. And in California, there's no inheritance tax. So in California, there's basically no death tax for any person who dies with an estate under $11.5 million. But if it is over $11.5 million, then an estate tax return would need to be filed, all right? Next, there's an estate tax portability election, and that really applies only to a surviving spouse of a person. And what that is, as I just mentioned, everybody can leave $11.5 million without there being an estate tax. All right, let's say husband dies and his portion or his estate is only $2 million. All right, what happens to the other $9.5 million of the 11.5 he could leave? Well, it used to be it would just kind of evaporate and go away. Now the surviving spouse has the option of reaching over and grabbing that unused portion and porting it, taking it over to their side, so that when they died, now they have that extra amount that they could leave. But the only way to make that election is through the filing of an estate tax return. And generally you have up to 2 years to make that portability election, all right? Next, another tax issue is the income tax basis. And what is that? A basis, and I'm going to speak in very general terms, and if you're a tax person, this may be fingerprints on the chalkboard. But a tax basis is basically what I call the baseline from which you determine if it goes up, you've got capital gains or tax. If it goes below that basis, you have capital loss. And generally, in most instances, the tax basis is what did you pay for it. When it comes to estates, however, the tax basis can be changed to what was it worth as of the date of death of the individual. For example, if mom and dad bought a house back in 1950 and they paid $20,000 for it, and when they died, it is now worth $820,000. Now you've got a $800,000 capital gain, right? Well, if they held that house until the date of their death, the tax basis is readjusted to what was the house worth as of their date of death, so all those capital gains could be wiped out. And that would be true of other assets that have a tax basis, such as stocks or other taxable assets. They could get a new tax basis as of the person's date of death. Now, frequently in our economy, that meant it would go up. You would have a basis hike. However, it's also possible that the basis could go down. If the asset lost money or was worth less than when it was purchased, then it would have a lower tax basis. All right. And property taxes, as we briefly discussed, the Prop 13 issue, changing when somebody dies can produce a taxable event. However, under Prop 13, if it goes from parent to child, that is one of the several exceptions to the ability to readjust or reassess the property. So that's one of the issues that the executor would have to look at, is what would be the impact on the property tax. Right. One of the major responsibilities of an estate executor is what we call marshaling the assets. And that's basically finding out what assets were in this person's estate at the time they died. And you do this through looking through all the different records, and you'd be surprised where assets might be found. So it's the job to identify and collect all the assets and property. And this may include the responsibility of collecting on loans that were made. But it's the duty to marshal the assets. And depending on the age of the person and what they were doing, you'd be surprised where you might find those assets. We were doing an estate for a lady who lived up in Pasadena, whose husband had passed away. And they had various assets in various states, including Massachusetts. And so it took a little bit of time to process the estate. About a year and a half after the husband had passed, the lady called up and said, "Hey, I found some stock that were in just my husband's name that I didn't know about." So we said, "Okay, how much was it?" She said, "Oh, it's worth about $30,000. We said, "No problem, we can handle that pretty quickly." She called us up a few days later and said, "I found some more assets." When she got done finding stock that were in just her husband's name that she didn't know about, that were just laying around the house, they were worth over $1 million. So part of the executor's job is to go through the house, go through the assets, go through the list, and find out what are all the assets. And one of the ways we frequently do this is by looking at old tax returns. And we do that by looking at the schedules on the tax return. Because if the tax returns show income from a certain asset coming in on one of the schedules every year, we find out where's that asset. So one of the main jobs of the executor is to locate the assets of the person's estate. And then they go about the transfer of assets. And how things are transferred depends on how they are owned. First off, assets can be owned in my name only. I could own things in just Dale Anderson, and that's just in my name. Then you can also own property jointly. And when I talk about jointly owned property in this instance, I'm talking about true joint ownership, what we call joint tenants with rights of survivorship. So if I owned an asset with John Smith and we own it jointly, when I die, who does that property belong to? Well, it belongs to John Smith immediately by operation of law. So how the assets are owned becomes very important. There's also a way of owning assets through what we call beneficiary designated property. You're typically aware of that in like life insurance policies or 401k policies. When you sign up for these policies, the first thing they find out is your name and what you want. One of the second questions they always ask is, who are the beneficiaries? And when you name somebody as a beneficiary in these type of assets, as soon as you die, the beneficiary designation prevails, and it can go to them. So those properties won't have to go through probate because of operation of law. They automatically become the person designated. So how the decedent own the assets becomes important, and that's part of the job of the executor, is looking at the various assets and seeing how were they owned. All right. So the assets can be transferred through the probate process, which is via the last will and testament, or what we call intestacy. At this point, I always ask people, how many of you have a will? And a lot of people raise their hand, or then I ask how many people don't have a will, and people raise their hand. I say, well, you're wrong. Because either you wrote a will yourself or through the use of an attorney, or the state of California wrote a will for you. And that will from the state of California is what we call the laws of intestacy. If you don't do anything, the state of California has set out what happens to your property and who gets it. Okay? Sometimes they get it right, but sometimes they get it wrong. And right now we're dealing with a process where a lady died. She had no family. Her parents were all died, predeceased her. She had no siblings, no aunts and uncles left. All she had left was a cousin. So the cousin filed for probate, but it turns out her dad had previously been married and had a child by that prior marriage. He was adopted out, and then he had kids and he got divorced, and they were adopted out. Well, it turns out the day before we were to have the hearing, child of the decedent's father filed, and it turns out under California law, half niece and nephew take over full cousin, even though the decedent had no knowledge that half niece and nephew even existed. So the probate process can be transferred either by will or by laws of intestacy, which is the California's will. Or it can be transferred via a trust, either a testamentary trust or a lifetime trust. All right. So what does a will do? The will names who gets all your stuff, who gets your estate. You can name in the will what happens to your assets when you die. Second thing it does, it names who's in charge, and that's what we're talking about, the executor. And when we say the will names the person in charge, the technical term is they nominate the executor. I've had people come to me and say, oh, I'm the executor, I'm in charge because I was named in the will. Well, not so fast, because the will nominates who's in charge, but the only way you get authority is by going to court. And the court designates the executor or appoints the executor. The will only nominates the executor, the court appoints it. Second thing, the will also only controls what's in your own name only. Remember the previous slide, we talked about different ways of holding title to things. But the only thing a will controls is what's in your name only. And finally, a will must go through probate. Again, I've had many people say, I'm going to avoid probate because I wrote my will, and so I'm going to avoid the probate process. Well, if you have a will, you've just guaranteed you're going through probate. So it's better for us to find out what is the probate process. First off, it's a legal process. And when we say a legal process, it means the state rules apply. The way we know what the rules are and what the process is by looking at the California Probate Code. You can't set up your own procedures. You can't set up your own process. Probate is a legal process that has to follow the terms of the probate code. Next, it can be very lengthy. We put in here a minimum of 18 to 24 months. One of the classic examples that we like to use is that of Marilyn Monroe. Now, many of you remember Marilyn Monroe died August 4, 1962, and her will was submitted to the New York Probate Court on August 17, 1962, and after initial hearings, it was admitted to probate in October of 1962. The will was not determined to be settled by the New York Probate Court until 2001. That's like a 39-year process. Now, obviously, that's an extreme, but it goes to illustrate that the probate process can be very lengthy. We had one in our own office here where a man died and he had two children, a boy and a girl. And he didn't have many assets, just a house and a boat. That probate process took almost 3 years to complete. So it's a legal process that can be very lengthy. And the control is with the court, not the family. So in other words, it's the court's timetable. And that's part of the process of being very lengthy. It's a process. When somebody dies, various notices have to go out, and we'll get to that in a minute. Also, the court's calendar controls when things happen. To start the probate process, you start by filing what's known as a petition to admit for probate. Once you file that, then you have to wait for the court hearing. We had one in Los Angeles County where we filed the petition for probate in February and did not get the first hearing until August. And until that process is completed, until that hearing takes place and the court actually approves and appoints the executor or administrator, there's nothing that can be done. There's no one with authority to actually do anything. So it's a court process, and the control is with the court. They determine when hearings are. They determine when you move from one process to the next. Next, everything is public. Once you file something in the court, in the probate court, it becomes public information. Right. Now, part of the process that I talked about, one of the documents that has to be filed as part of that probate process, and which is part of the executor's duties, is what's known as an inventory and appraisal. Now, that document is basically just what it sounds like. It's an inventory of all those assets you just marshaled and an appraisal of how much were those worth, okay? Some of those assets are easily to determine what the value is, such as bank accounts. Those the executor can do themselves by just recording what assets were in a certain bank account as of that date. However, other assets, anything that does not have a set value, such as houses, cars, stocks, bonds, anything like that, those have to be quote unquote appraised. Now, who does that? The court appointed appraiser. So they have to go through and look at all of those assets and put down what the value of those assets were. That document, that inventory and appraisal thing gets filed with the court. And what did I say when a document gets filed with the court? What is it? That's right, it's public. So remember that cousin Jackie who you couldn't stand throughout your life? Once that document gets filed, she can go to court and see everything you owned and what was it worth. Next, the cost can be very expensive. All right, this is what we're talking about, the legal process of the probate court. The court sets all the dates. Notices go to all the heirs and beneficiaries. Now, what's the difference between an heir and a beneficiary? A beneficiary simply is someone designated in the document to benefit from the document. Right? That's a beneficiary. What's an heir? Now, remember I told you that everybody has a will. Either it's one you make yourself or it's one the state of California wrote for you. But an heir is who are the state of California's quote unquote beneficiaries. In other words, who does the state of California say would take the property if the person died without a will or other estate planning document? Those are who the heirs are. All right. So under the probate code, notice goes to both heirs and beneficiaries, notifying them of the fact that the probate process is starting and that the executor is petitioning to be named as the executor. We already talked about the notice that goes to the Department of Healthcare Services. Publication has to be in the newspapers. And maybe you've seen some of these publications during the weekend newspapers or some of your local newspapers of notice of probate. So the law requires that publication has to be made at 3 different times in a paper of local circulation, regular circulation. You have to give proof of that publication to the court as part of the process. So this is all part of the legal process that results in delays, and these are some of the duties of the executor. It becomes very public. Like I indicated, the inventory and appraisal gets filed with the court. How do we know how some of these celebrities and how much money they have? It's because they went through probate and their inventory and appraisal was filed. It also results in fighting among family members. All of that becomes very public. Now we have here the example of Prince's estate. Remember, Prince died a couple years ago. And anybody know what his will said? That's right, he didn't say anything because Prince died without a will. So that meant his estate had to go through probate. And then when we talk about notices of beneficiaries and heirs, well, heirs started coming out of the woodwork. All these different people started filing saying I was a love child or I was somehow related, so I'm entitled to his estate. And all of that started becoming part of the process. And all of it becomes very public. And like I say, it's not just celebrities where that happens, it's also private individuals. There are companies, and the reason I know this is because we had this happen in one of our probates, companies that go through the probate filings to see who filed and who might be unnamed beneficiaries, and then they contact. There are air search people. We actually had some people intervene in one of our probates where they had no idea who the decedent was, but one of these air search people that went through the public records down at the county courthouse said, oh, we think you might be a beneficiary of this estate, and if we'll tell you who it is if you give us a percentage of it. And so that's what they did. But all that is because it's a public filing. But it's part of the executor's duty of making all these filings. The costs of it. The costs are set by statute, all right? And it's basically 4% of the first $100,000 of the estate. It's 3% of the next 100,000 and then 2% of the next 800,000. So we got here a chart showing that at a simple estate of $100,000, the attorney fee set by statute is $4,000. If you have a simple estate of probate estate of $200,000, the attorney fee set by statute would be what? $7,000. So the result is that in a simple estate of $1 million, you're looking at attorney fees of $23,000 set by statute. And when we talk about an estate of $1 million, in California, that is not very unusual. Because if you own a house in California, you're already close to that $1 million. And when we talk about the value of the estate on which the attorney fees and fees are set, it's on the gross estate. And that means it doesn't matter if you have $1 million house and you have $800,000 mortgage on it. It's still based on the $1 million. Okay. So the value of the gross estate determines what the attorney fees are. Now here's the other kicker. If you have an executor named in your will, the executor gets the exact same fees as the attorney. So if we're talking about a $1 million estate in California, you're talking about $46,000 in fees, $23,000 for the attorney and $23,000 for the executor. All right, and it's based on that appraised value of the estate. Remember, I talked about the inventory and appraisal, and that the probate appraiser is going to set the value of these assets. Guess what the appraiser's fees are based on? They're based on a percentage of the value of the estate. So they have some incentive of having the estate valued more. So part of the fees and expenses that are included in the probate process are those of the attorney, those of the probate appraiser, but there's also other fees. Remember I talked about the publication. They could cost anywhere, depending on what newspaper you publish in, anywhere from $600 to over $1,000 to publish that. Then every time you file something with the court, you have to pay a fee. A petition to open probate, there's $500 filing fee there. A petition to close the estate, there's another $500. Anytime you file a petition asking the court to do something, it could be an additional fee. So all those fees and expenses begin to add up after time. So you can see that a probate estate can be quite expensive. All right, now we come to what are some of the common beneficiary concerns, and these are different concerns that the executor would need to deal with. Number one concern that we get from beneficiaries is lack of communication. The executor or who's ever administering the estate just isn't keeping them appraised of what's going on with the estate. And there are certain duties of the executor. I like to say there are two basic duties of an executor or trustee or administrator or who's ever handling a person's estate. Number one duty is to do what the document says. If in this case, when we're talking about an executor, we're talking about a will. The number one duty is to do what the will says. The number two is do what the law says. And frequently it's in that order too. In the example of a will, you do what the will says unless it's against public policy. For example, a will can't say that the executor doesn't have to follow fiduciary principles. That's against public policy. You still have to follow fiduciary principles. And one of those principles are to keep the people appropriately notified of what's going on. And you're going to do that through various notices. Every time you have to file something with the court, notice has to go to all the appropriate heirs and beneficiaries. Even in probate, if you want to sell real estate, notice of proposed actions have to go out. So one of the problems that we frequently encounter is that the beneficiaries are not kept appraised of what's going on. Another beneficiary concern is delays. And sometimes that's just a matter of perspective. They don't understand the process. They don't understand that it takes a long time to do some of these actions. But the executor is one that's going to have to field all those complaints of why is it taking so long? Why is it taking over a year since dad died? Why have I not gotten my distribution? They don't understand the process. So part of the executor's duty is to communicate as to what these different delays are. There's also sometimes a perception of favoritism, that the executor or the administrator or who's ever handling the person's estate is treating one sibling or one beneficiary over another. Part of the fiduciary principles is that everybody has to be treated equally, the same. Not necessarily equally in that they get the same distribution, because the will itself may say one person gets more than another, but they have to be treated the same in that each person is getting their share at the same time. All right. Sometimes the executor thinks, well, I'm the boss, I'm in charge, I can do what I want. Well, in California, that's not the case. Even if you're given what they say absolute discretion under the document, the California Probate Code requires that that discretion be handled pursuant to fiduciary principle. You still have to follow the law. You still have to handle each of the beneficiary complaints and request for information appropriately. Another problem that we've seen is lack of communication with the attorney. Following through with the attorney, finding out what's going on, following where the process is. Number 6 is the lack of follow through with the settlor, or the person who made the will in this case. The person who made the will may have intended to make a distribution to someone, but then they didn't follow through with it. So in California, the rule of law is not what did the decedent intend to do, or what did they intend to say, it's what did they intend by what they did say. So the person, the decedent, may have failed to follow through on what they intended to do, which brings us to the next common beneficiary concern, is that they were told they were going to receive an item or distribution and didn't receive it. Well, that may be true, but the executor, again, is going to have to handle all of these different concerns arising from the beneficiary. Just because the decedent said they were going to get something doesn't mean they actually intended on giving it to them, and they may not have followed through by actually writing it down. Because unless it's actually written down, it doesn't count as an actual distribution. You can't go to court with a verbal promise to make a distribution. The person has to actually have written it down. And then another common concern is not receiving a copy of the estate plan, in this case the will, or if it's a trust is involved, a copy of the trust. And this is all, again, part of the process of lack of communication, that the executor hasn't kept all of the people appropriately appraised of what's going on or answering their question. So these are just some of the common beneficiary concerns that the executor might face. So as you can see, there's a lot of different issues for an executor. There's a lot of different responsibilities, so that if you are named as an executor, this is what the process that you would have to adhere to. These are different things that you'd have to follow through with. Or if you're thinking about who to name as an executor, you have to question, is the person I'm about to name, are they the right person to do each of these steps? So that is important as far as in your estate planning process as well. So we are here for you. And at this point, I think I will turn it back over to Kara to finish this up.
Dale, great job. As Dale mentioned, the Kopenbarger Law Firm has been in business for over 40 years. We have 8 full-time attorneys and 1 of-counsel attorney, along with a full-time CPA and over 30 support staff members that are highly qualified to serve your every need. We have offices all over the state of California, 7 to be exact, and can meet with you in person or through virtual means such as Zoom. Our team will be sending out an email with the recorded webinar so you can share it with your family and friends. As Dale stated, it's extremely important to have proper estate planning in place so you don't have to deal with the hassle and high costs of probate. Because you tuned in today, you are eligible for a complimentary consultation with one of our certified specialists. Whether you need to establish an estate plan for the first time or need to review your existing estate plan, your consultation is completely free. Remember, we're here to help you through all the stages of your life and appreciate being your expert referral for all your professional needs. We look forward to serving you and your family for many years to come. Thank you so much, and we hope you have a wonderful day.